I got a good question on our Drake Law Firm's website this morning from an individual who wanted to know if an arbitration clause that she signed when she admitted her mother to a nursing home, whether or not that can be enforced in Alabama courts. The answer is it depends, but usually it will be enforced. Sadly, most people that want to put or have to put their loved one or their parent into a nursing home, they're always given a bunch of documents they have to sign. I'm the sponsor, I realize that, and etc. And there's usually an arbitration clause in those documents. Well, what is an arbitration clause? An arbitration clause is a document that you sign that basically says you can't file suit against who's asking you to sign that document. Now, there are many cases where we get around that so we can actually file a lawsuit for the death or serious injury of a loved one by finding, or in the contract of arbitration, some exceptions. For example, if the person you're wanting to admit to the nursing home, if they sign the documents, but they're not mentally competent or they're suffering from dementia, we can usually get around the arbitration clause. So there are ways to get around the arbitration clause, but basically an arbitration clause is held to be valid. Basically means you cannot sue that nursing home. So we would encourage people to avoid signing those when you're admitting your parent or loved one into the nursing home. But also, even if you do sign one, there are several exceptions and ways to get around them. So if you have a nursing home case, or they dropped your parent, or they injured your loved one and they died from that, or had to have surgery or something serious, contact us and let us review your unique circumstances for you.